I have been requested to render a legal opinion regarding the ability to award the water meter project number 357-83300. In rendering this opinion, I have reviewed all relevant bid documents, and it is the opinion of this office that the Honorable Council of the City of Findlay may proceed to award the water meter project number 357-83300.
Mr. Greeno.
Yes, I guess the question is for Jim. Does this letter satisfy your criteria for the bidding process, Mr. Staschiak?
Thanks for the question. My responsibility as city auditor was to review the process and lay out all the issues appropriately, and I have done that. Having raised the issues, I recognize it is the responsibility of the law director to review. And since that time, he has written this opinion. I will respect the decision, having raised the issue. As to the matter in front of you, I will defer.
So basically, according to this letter, it's the opinion of the city's legal counsel that we could proceed with this project. I believe that the auditor still has issues with this project. So if we move forward with this project, I guess, is this something that could eventually end up in the courts? And I guess this question is for Mr. Rasmussen.
Thank you, Don. If this body passes this legislation, what that means is, based on my duties and Don's opinion, I would sign the legislation you passed, provided it's presented to me properly, and it'd be no different than any other piece of legislation that's presented to me. Does that answer your question, Randy? It does.
Mr. Paulin.
Question for Jim. Would you be signing a protest letter, essentially? If you sign the legislation? No objection?
No.
I would like to address these concerns. The first of these issues deals with the fact that the criteria engineer failed to notify the Ohio Facilities Construction Commission. This notice is procedural in effect and has nothing to do with the substantive issues regarding this matter. This notification did not ensure or otherwise guarantee that any specific bidder or bidders would have or could have responded to such an inquiry. However, the engineer did advertise in all the usual places and or publications pursuant to the Ohio Revised Code, as has been done for years. The fact that 3 qualified firms submitted 3 quality proposals together with another firm that declined to submit its proposal is proof positive that there was adequate public notification of the project. With regard to the development of actual bid specs, I have reviewed their communications and have discussed the process with both Brian and Jason. It is my opinion that the specs were fairly and appropriately developed and discussed with all parties involved in this process. The owners, taxpayers, and contractors are all beneficiaries of competitive bidding laws and protections. The goals of competitive bidding are to ensure that the public gets a good contractor for the project and at the best price, and that the process is fair. However, whether the bidding was competitive from the bidder's viewpoint is not the issue. The issue really is whether the bidding was competitive from the city's viewpoint so that the public would obtain the lowest and best price for the project. In my opinion, this was accomplished. In the unlikely event a rejected bidder would seek judicial review of a decision by a public authority pursuant to the bidding statutes, the court must apply an abuse of discretion standard. In other words, the court does not substitute its judgment for that of the public authority empowered by statute to make the award. Rather, even if the court disagrees with the public owner's decision, it should not disturb the decision unless it finds an abuse of discretion. So what does that mean? An abuse of discretion means more than a mere error of law or judgment. It means an unreasonable, arbitrary, or unconscionable attitude. Arbitrary means without adequate determining principle, not governed by any fixed rules or standards. Unreasonable means irrational. Dayton ex rel. Sandrick versus McGee, 1981, 67 Ohio State. In this case, there is no abuse of discretion present. In other words, regardless of whether the court would have reached the same conclusion, the court is limited to determining whether the decision is one that a rational person could have made based on information available at the time. This places a high burden of proof on the bidder challenging the decision. Merely arguing that the public owner weighed the information incorrectly will not suffice to overturn public owner's decision. Finally, and most importantly, the legislative power of each city is vested in and exercised by the legislative authority. If council votes to proceed with this project, all elected officials and city personnel will be bound by its decision, including the auditor. It is my opinion that the city of Findlay may proceed to award the water meter replacement project, project number 357-833-00.
Aye.
Mr. Niemeyer,
Abstain.
Mr. Palmer,
Aye.
Mr. Russell,
Aye.
Mr. Schindelbecker,
Aye.
Mr. Slough,
Aye.
Aye. Mr. Wolfser,
Aye.
Mr. Greeno,
Aye.
Mr. Haas,
Aye.